Hey everyone, it's time to think like a lawyer. I've been following the legal chaos unfolding here in California, and trust me, this one's a constitutional earthquake. Just a few days ago, Governor Gavin Newsom signed a sweeping gun control package straight into law, and yes, it's already being called the most aggressive set of firearms restrictions in state history. We're talking about AB 1127, better known as the Glock ban, SB 704, the background check on barrels bill, and AB 1078, a new rule that limits Californians to 3 firearms transactions per month. Each of these laws was signed at the state capitol in Sacramento and is scheduled to take effect beginning April 1, 2026 for AB 1078 and July 1, 2026 for SP 704 and AB 1127. So today, I want to break down exactly what's inside these new laws, why gun rights groups like the Firearms Policy Coalition, FPC, and Gun Owners of California, GOC, are already preparing lawsuits, and how this fight could shape the future of the Second Amendment across the entire United States. Because make no mistake, what happens in California never stays in California. Before diving into the new laws, let's zoom out for a second because this didn't come out of nowhere. California has long been the most aggressive testing ground for gun control in America. From the state's first assault weapon ban in 1989 to universal background checks, waiting periods, and microstamping requirements, California has built what many call the most restrictive framework on firearm ownership in the country. But every time a new law gets passed, there's a constitutional fight waiting around the corner. One of the biggest is Miller versus Bonta, a landmark federal case that challenges California's assault weapons ban as unconstitutional under the Second Amendment. The judge in that case, Roger Benitez of the Southern District of California, has repeatedly ruled that the state's bans violate citizens' rights, citing the standards set by New York State Rifle and Pistol Association versus Bruen, 2022. That Supreme Court decision completely changed the game. It states that modern gun laws must be consistent with the nation's historical tradition of firearm regulation. Translation: unless there's a clear historical precedent from the 18th or 19th century, it's probably unconstitutional. Now, that standard has become the measuring stick for every lawsuit that follows. And trust me, California keeps giving lawyers plenty of material. So when Governor Newsom stood at the state capitol in Sacramento earlier this October and signed this new gun control package, including SB 704's barrel background check requirement, it wasn't just another round of regulation. It was the opening shot in what's shaping up to be one of the most consequential Second Amendment battles in modern times. And if history is any guide, it's not going to stay within California's borders, because once one blue state passes a new gun restriction, others tend to copy it within months.
All right, let's break down exactly what these new laws do, why they're controversial, and when they kick in. First up, AB 1127, also called the Glock ban. This bill prohibits the sale of several popular handgun models, particularly Glock pistols, that can be easily modified with illegal conversion devices known as Glock switches. Those tiny pieces of metal can turn a semi-automatic handgun into a fully automatic weapon. Lawmakers argued that these conversions are increasingly being used in crimes and that California's old safe handgun roster wasn't enough to stop them. Supporters, including Governor Gavin Newsom and Attorney General Rob Bonta, say the goal is simple: stop the spread of easily converted handguns. But critics, including the Firearms Policy Coalition, FPC, and Gun Owners of California, GOC, call it a backdoor handgun ban, one that effectively wipes out an entire class of legal firearms from the California market. According to the bill, AB 1127 will take effect on July 1, 2026. Next, there's AB 1078, which limits Californians to 3 firearm transactions per month. The state claims this prevents bulk purchasing and illegal resale, but here's the kicker. Even the Ninth Circuit Court of Appeals previously struck down the similar one-a-month law as unconstitutional. Now, lawmakers are doubling down with a stricter version, and lawsuits are already lining up to challenge it again. AB 1078 takes effect April 1, 2026. And then there's SB 704, the so-called background check on barrels bill, one that hasn't gotten as much attention, but could have huge ripple effects. Starting July 1, 2026, anyone buying or transferring a firearm barrel or certain key components will have to go through a licensed firearms dealer, FFL, and pass a background check, the same process as if they were buying a complete firearm. Dealers will also be required to record the buyer's ID, address, and the make, model, and caliber of the part being purchased. Supporters argue this closes a ghost gun loophole that allowed criminals to build untraceable weapons by buying components online. But opponents say it's another bureaucratic overreach that targets law-abiding citizens, the people who are least likely to commit crimes. And, just like AB 1127, SB 704 exempts law enforcement and government agencies. What's striking is how Governor Newsom handled these signings. Usually, he turns gun control into a media spectacle, big press events, moms demand action on stage, the whole show. But this time, he signed all three bills quietly, behind closed doors at the California State Capitol in Sacramento. That silence is telling, especially from a governor who's rumored to be eyeing a 2028 presidential run. Because if these laws backfire, and they very well might, it won't just hurt his state, it'll ignite a constitutional storm across the country.
As soon as those bills hit Governor Newsom's desk, the reaction was immediate and explosive. Within hours of the signing, the Firearms Policy Coalition, FPC, issued a public statement calling AB 1127 an unconstitutional, bad-faith attempt to outlaw some of the most common handguns in the United States. Their message was blunt. No tyrant, no politician, and no state will be allowed to extinguish the rights of a free people, not now, not ever. That's strong language, but it reflects just how high the stakes are. The FPC, alongside the California Rifle and Pistol Association, CRPA, and the Gun Owners of America, GOA, have already pledged to challenge AB 1127, AB 1088, and now SB 704 in federal court, most likely in the Southern District of California, the courtroom of Judge Roger Benitez, who's already ruled multiple times that California's gun laws violate the Second Amendment. Their legal argument is clear. Under the Bruen test, the state must prove that any modern firearm restriction aligns with the nation's historical tradition of gun regulation. And there is no historical precedent for forcing background checks on gun barrels or limiting citizens to 3 firearm purchases a month. On the other side, Governor Newsom and Attorney General Rob Bonta are calling these measures common-sense safeguards. They argue that the bills close loopholes that allow criminals to build ghost guns and prevent dangerous stockpiling. In their view, California's gun death rate, one of the lowest per capita in the country, proves the approach works. But legally, the battleground is far from settled. The Ninth Circuit Court of Appeals has a history of both upholding and striking down California's gun laws, and every case ends up a tug-of-war between public safety and individual liberty. This isn't just a policy disagreement, it's a constitutional showdown. And SB 704, with its expansion of background checks to mere components, might be the case that finally tests how far the Second Amendment really goes in the modern era. Let's step away from the courtroom for a moment and talk about how this affects real people, because these laws don't exist in theory. They hit everyday citizens square in the pocketbook. If you're a gun owner in California, starting April 1, 2026, AB 1088 will cap you at 3 firearm transactions per month. Even if you're a licensed collector, competitor, or instructor, you'll hit that ceiling fast. Then, on July 1, 2026, AB 1127 will take away an entire category of handguns, including the latest Glock models that don't meet the new roaster standards. And that same summer, SB 704 will kick in. That means even buying a replacement barrel, upper receiver, or other regulated firearm components will require a background check through a licensed dealer. You'll need to pay the same fees, file the same paperwork, and endure the same waiting period as if you were buying a whole gun. Dealers across Los Angeles, San Diego, and Sacramento are already warning that these combined laws could drive up prices and push legal buyers out of state. Some predict losing up to 40% of annual sales once these restrictions take effect. And history gives us a warning here. When California implemented ammunition background checks in 2019, tens of thousands of lawful buyers were wrongly denied due to database errors, while criminals still found ways to get ammo through illegal channels. That same pattern could repeat with SB 704. Compliance punished, circumvention rewarded. Meanwhile, law enforcement and government agencies remain exempt, meaning the very people enforcing the law face fewer restrictions than those expected to obey it. That double standard drives the resentment driving these lawsuits. If the courts step in, we could see temporary injunctions blocking one or more of these laws before rollout.
But if they survive judicial scrutiny, California will set a new national precedent, effectively extending full gun purchase regulation to even the smallest firearm parts. And once that door opens, you can bet other states, New York, Illinois, Washington, will be watching closely, ready to follow suit. Because when California moves, the rest of the country often follows.